Well, first, I'd like to thank Women for Kansas for inviting me to speak here to the Taking Back Kansas Convention and giving me the opportunity to talk about voting rights in Kansas. Barbara's story highlights a couple of the key problems with the recent changes in Kansas voter law. First, the laws have become too complicated. Second, the state government has not done enough to educate the public about these new laws. The fact that Barbara's expired driver's license, that's in fact for somebody over 65 an acceptable form of photo ID under the law. So if the poll worker hadn't known her, she would have been able to present that and vote anyway. But she didn't know that because there's been insufficient public education about that. Secretary Kobach's main educational initiative in this regard was to create a website, gotvoterid.com. But my guess is that few voters and even fewer seniors go to the web for their tutorials about voting law changes. But those problems, complexity and lack of public education, are only the tip of the iceberg. And so today in my remarks, I want to flesh out the rest of the iceberg. 2014 is a year of anniversaries for civil rights and civil liberties in the United States. It's the 60th anniversary of the Supreme Court's decision in Brown versus Board of Education. It's the 50th anniversary of the passage of the Civil Rights Act of 1964. And it is also the 50th anniversary of the Supreme Court's decision in Reynolds versus Sims, which along with Baker versus Carr is one of the most important voting rights cases ever decided by the Supreme Court. In Reynolds versus Sims, the court noted that, quote, history has seen a continuing expansion of the scope of the right of suffrage in this country. The right to vote freely for the candidate of one's choice is of the essence of a democratic society, and any restrictions on that right strike at the heart of representative government, end quote. At least until recently, Kansas's history tracked that of the nation by expanding the right to vote. Let's review some of that history. On October 4, 1859, the people of the Kansas Territory approved the Wyandotte Constitution. And Congress approved that state constitution when it passed the bill that admitted Kansas to statehood in late January 1861. The debates in the Wyandotte Convention were contentious. Among other things, the Wyandotte Constitution granted property rights and equal custody of children to women, which were not rights commonly enjoyed by women in antebellum America. The debate over universal suffrage was one of the issues that bitterly divided the delegates to the Wyandotte Constitution. The delegates ultimately rejected universal suffrage and fully enfranchised only white male citizens over age 21 who had resided in Kansas for 6 months and in the township or ward in which they wished to vote for at least 30 days next preceding the election. The framers of the Wyandotte Constitution also specifically provided that the, quote, the legislature shall pass such laws as may be necessary for ascertaining by proper proofs the citizens who shall be entitled to the right of suffrage hereby established, end quote. That little ditty causes problems today. Under the Wyandotte Constitution, women were given the right to vote only in school board elections, which the delegates apparently saw as a topic of special concern for women. While this provision may now strike us as backward and regressive, giving women the right to vote in school board elections was actually a radical step in 1859 because at that time, only Kentucky allowed women to vote in such elections. In contrast to women, the Wyandotte Constitution completely disenfranchised Native Americans and blacks. Many Kansans worked tirelessly to advance the cause of universal suffrage even before Kansas officially entered the Union on January 29, 1861. And that work continued and picked up steam after Kansas became a state. In 1867, suffragists succeeded in putting 2 constitutional amendments on the ballot that would have extended universal suffrage in Kansas. One provision proposed eliminating the word white from the suffrage provision of the Kansas Constitution, and the other would have given women the right to vote in all elections. But the all-white, all-male electorate rejected those measures on November 5, 1867. Women's suffrage came to Kansas in incremental steps. Although suffragettes were active in Kansas from the earliest days, the movement really took hold in 1884 with the founding of the Kansas Equal Suffrage Association. In 1887, women gained the right to vote in municipal elections, and many women were elected to municipal government offices. In fact, Susanna M. Dora Salter became the first woman elected to any political office in the United States when, on April 4, 1887, those forward-thinking people of Argonia, Kansas, elected her as their mayor. But after that, further progress on women's suffrage in Kansas hit a snag. In 1894, for instance, voters once again rejected an equal suffrage amendment. But finally, on November 5, 1912, voters approved the equal suffrage amendment to the Kansas Constitution. Thus, women in Kansas got the right to vote 8 years before the ratification of the 19th Amendment, which gave women the right to vote throughout the nation. Yes. A long time in coming, but it came. More recently, in 1971, Kansas amended its state constitution and also approved the 26th Amendment to give 18-year-olds the right to vote. And more recently than that even, Kansas has engaged in some expansion of advanced voting to allow people to vote at their convenience. So, to recap, for the first 150 years, Kansas was on a one-way street leading to gradual expansion of voting rights. But shortly after Kansas's sesquicentennial on January 29, 2011, that history changed. Indeed. In November 2010, Kansas elected Kris Kobach as its Secretary of State. In that race, Professor Kobach's campaign signs bore the message, "Stop voter fraud." In 2011, the Kansas legislature passed and Governor Brownback signed the so-called SAFE Act. SAFE stands for Secure and Fair Elections. Who can be opposed to that, right? Secretary Kobach was the driving force behind that legislation, which substantially amended many facets of Kansas voting law. Among other things, the SAFE Act cut back on advanced voting and imposed onerous new requirements for voter registration. Today, I primarily want to talk about 2 parts of that law, specifically the photo ID requirement and the documentary proof of citizenship requirement. The SAFE Act provides that effective January 1, 2012, voters must show photo identification in order to cast the ballot. And I could give you the laundry list of things that are acceptable, but let's just say the list was longer than in a lot of the other states where you've read about successful challenges to photo ID. So they did a better job than other states in making that list of photo ID acceptable. But the original law left out certain things, certain obvious kinds of photo ID, and the most obvious one was it didn't recognize tribal IDs for Native Americans as acceptable photo ID for voting. It also didn't provide for people who were born out of state an easy way and cost-free way to get a non-driver's license ID card that they could get without obtaining their out-of-state birth certificate, which can cost upwards of $20. The second part of the law I want to talk about is that effective January 1, 2013, new voters seeking to register for the first time or who move have to provide documentary proof of citizenship in order to be entered on the voting rolls. The law contains a list of things you can provide for proof of citizenship, including a passport and a certified birth certificate. For years, Professor Kobach has claimed that requiring photo IDs and documentary proof of citizenship is necessary to combat widespread voter impersonation fraud at the polls and illegal voter registration by non-citizens in Kansas and throughout the nation. In 2010, he made those claims the focus of his election campaign. But there's simply no evidence to support Secretary Kobach's claims of rampant fraud. In fact, the Kansas City Star has reported that between 2004 and 2009, there were only 7 cases of alleged electoral fraud in Kansas. And only one of those cases led to a prosecution. In addition, Ron Thornburg, the last Republican Secretary of State before Secretary Kobach, has said that voting fraud is not a significant problem in Kansas. Moreover, reports prepared by the Brennan Center for Justice and other institutions like it have clearly shown that impersonation fraud just doesn't exist in any appreciable numbers anywhere in the country. Illegal voting is extremely rare. But when it does occur in Kansas, it usually occurs as it does in other states, when people register and vote in 2 jurisdictions under their own names, or when people move but return to their old precincts to vote. These rare cases of voter fraud are usually discovered, and if they involve intentional misconduct, the wrongdoer is prosecuted. About 10 years ago, for instance, a Kansas City, Kansas lawyer voted several times in both Missouri and Kansas in the 2000 and 2002 election cycles. He was caught, prosecuted, and convicted. As a result, he has forfeited his right to vote forever. That's the penalty for voter fraud. And apparently it works because that's the only prosecution in recent times in Kansas. Likewise, there's no real or systemic evidence that citizenship impersonation occurs. The few cases where non-citizens have registered and voted have usually turned out to involve misunderstandings, mistakes, or plain foolishness. There's no evidence of an organized effort to register non-citizens to throw elections. But with the mounting number of voters on the suspense list in Kansas, there is clear evidence that the cure for this non-existent problem is far worse than the malady it seeks to remedy. So many people who register in Kansas, like elsewhere in the country, do so when they get their driver's license. The problem is the proof of citizenship requirement caused a bottleneck because there was no way for the Department of Revenue's offices to transmit those documents, to collect, store, and transmit those documents from DOR to the Secretary of State's office or the local election authorities. Since the citizenship requirement took effect, the number of voters on the suspense list has mounted to outrageous levels. At one time last year, for instance, the suspense list had grown to over 20,000 people. Recent press reports have indicated that there are still over 18,000 people on the suspense list. Historically, there have always been people who failed to complete their voter registrations. Usually that's been because they forgot to sign their registration application or they forgot to provide their address. But before 2013, the statewide suspense list never had more than a few hundred names on it. And those names had accumulated slowly over many, many years. In fact, some of the names on the suspense list before 2013 had been on that list for more than 20 years. With the advent of the documentary proof of citizenship requirement, however, the number of names on the suspense list exploded, increasing by about 40-fold in a matter of months. And that has consequences, because if your name is on the suspense list, you cannot cast a ballot that counts. That's because in order to be fully registered, Kansas law has long provided that you have to appear on the voter rolls. 3 weeks before the next election. And if your name isn't on the voter rolls, you're not able to vote. If you haven't provided documentary proof of citizenship, your name won't be entered on the rolls and you won't be able to cast a meaningful ballot. If those folks on the suspense list go to the polls, the election worker may give them a provisional ballot, but that ballot will never be counted because the voter was not fully registered 3 weeks before the election. Moreover, there's no way to fix that problem after the election. In contrast, if you go to the polls and forget your photo ID, you have a valid ID, you just forgot it at home, you'll get the provisional ballot. You can cast that ballot. And as long as you go back before the canvass to the election authority, and many election authorities have made this pretty easy, you can even fax it to them, and show, I have an ID, your ballot will be fully counted. That's not the case with the people on the suspense list. If you're not on the voter rolls, no vote. Now, however, because of the enormity of this problem created by the SAFE Act citizenship requirement, Secretary Kobach has seen a slight light. He has created a convoluted system to try to redress this slightly. And in particular, he's told the local election authorities, okay, if somebody comes in within the 3-week period, but before the vote, and shows documentary proof of citizenship that's adequate, you can go ahead and consider them to have been fully registered 3 weeks before the election. But that doesn't help you unless you provide it during that 3-week period. You can't provide it on election day, and you can't provide it afterwards. So these people, many of these people on the suspense list, thousands of people, are SOL. Their votes will not count. Before the advent of the SAFE Act, since time immemorial, people in Kansas had been able to register to vote by signing and affirming that under penalty of perjury that they were citizens. Last summer, and the Supreme Court said that if you use the federal voter registration form, which just contains an affirmation of citizenship, the states must accept that as registration proof. Secretary Kobach didn't like that Supreme Court decision that said that, and so he sued the U.S. Election Assistance Commission to try to get the federal form in Kansas changed so that it would list proof of citizenship documents as a requirement before you'd be able to vote in Kansas using the federal form. That case was argued in front of the Federal Court of Appeals earlier this week and will probably be decided by the election time. But it's small potatoes. Not that many people use the federal form in Kansas, and it won't have a major effect on the election. Secretary Kobach also doesn't like the federal form, so he created another convoluted system, and that was that he told the local election authorities, okay, for voters who use the federal form, since the Supreme Court says we have to accept it as proof of registration for something, we'll accept it only for federal elections. So you can't vote, if you use the federal form and don't provide documentary proof of citizenship, you cannot vote in state and local elections. You can only vote for federal races, which that means for your congressman and this year in Kansas, your senator. Sometimes there wouldn't be a senator, so you'd be voting for one candidate. Okay. Voters under this system, voters who use the federal form but don't provide proof of citizenship documents can only vote in federal elections. Voters who use any form but provide documentary proof of citizenship can vote in all elections. People who use the Kansas voter registration form but are too busy to go and get their proof of citizenship documents and take it back to the election authority or send it in, and there are many people like this, they can't vote at all. All right. I don't really expect you to understand the legal morass I've just described. And in fact, that's exactly the point. The SAFE Act has created a system that is overly complicated and hard to understand, and that has the terrible effect of putting nearly 20,000 people on the suspense list, a kind of voting never land. In sum, the Kansas legislature and Secretary Kobach have created a convoluted system in which voters who register using the federal form can only vote in federal elections. People who don't provide any proof of citizenship can't vote at all if they used anything else. And you've got to take time out of your day to go prove what everybody knows is the fact that you are, in fact, a citizen. So, you may ask yourself, what is the ACLU doing about these laws? First, let's consider the photo ID requirement. When the SAFE Act was introduced in the legislature in early 2011, the ACLU and various coalition partners lobbied against the bill, using many of the arguments I've just related to you. On March 23, 2011, however, the Kansas Senate voted in favor of the bill by a margin of 36-3, with one member not voting. At that time, there were 8 Democrats in the state Senate, and 6 of those senators voted for this bill. The Republican senators voted for the bill by a margin of 30-1. When the bill reached the House on March 29, the members approved it by a margin of 111-11, 3 members not voting. 22 Democratic state representatives voted in favor of the bill, and only 10 Democrats voted against it. Despite the clear factual evidence that photo ID laws and proof of citizenship laws are unnecessary and actually make it harder for people to vote, the Kansas legislature passed the SAFE Act by overwhelming bipartisan margins in both houses. Upon passage of the SAFE Act, moreover, the ACLU and our coalition partners started to investigate the impact of the law and to raise awareness about gaps in that law that would create hardships for various classes of voters. For instance, we met with representatives of the largest Native American tribes in Kansas, and we mounted a public education effort to push back against the Rube Goldberg-like regulatory schemes that Secretary Kobach adopted to implement the law. Yeah, thank you, but the sad fact is that didn't have much effect. The 2012 legislative session, furthermore, during that we mounted a lobbying campaign to at least get the list of photo ID expanded to include tribal IDs, and partly through our work and the tribes themselves, that was passed. Secretary Kobach also tweaked his regulations some to make it a little easier for people born out of state to get a non-Kansas or a Kansas non-driver's license ID card. We also looked at litigation, but by the time Kansas adopted this law, the U.S. Supreme Court had decided in 2008 Crawford versus Marion County Election Board, in which the court rejected a challenge to Indiana's photo ID law. Although we spent considerable time looking to try to find people who were adversely affected by this law, we found very few Kansans who actually did not have qualifying photo ID, partly because the list is longer in Kansas. It is better. So we decided not to mount an immediate legal challenge to this. Instead of filing suit, we decided to monitor the law's implementation and effects. So far, we've seen the law in the 2012 election cycle and the 2014 primary. Since the adoption of the SAFE Act, the law's photo ID requirement has caused some confusion and problems at the polls, but frankly not huge problems. In 2012, for instance, there were news reports about confusion at the polls regarding whether high school photo ID cards would count as adequate proof of photo ID. They do not. It's only post-secondary student IDs. During the primary election earlier this month, a poll worker in Topeka turned away some residents of Brewster Place retirement community when they showed up without their photo IDs. The poll workers should have allowed those people to vote a provisional ballot. So this was a case of poor poll worker training. Unfortunately, some of the people returned to their retirement home and were unable to come back to the polling place with their photo ID, so they didn't get to vote at all, even though they wanted to. Although these incidents show that photo ID law, the photo ID law has caused some problems, we have not yet found any evidence that it is disenfranchising large swaths of Kansas voters. Nevertheless, we continue to monitor the law and its impact, and we may file a lawsuit challenging the photo ID requirement if we find evidence of such widespread voter suppression effects later. Recent developments in litigation around the country on photo ID laws bear some mention. In Arkansas, Pennsylvania, and Wisconsin, courts have struck down these laws either on federal or state constitutional grounds. In North Carolina and Wisconsin, courts have either upheld the laws or refused to put them on hold in this election cycle. Now, I know I just mentioned Wisconsin twice, and I'll explain why. I haven't lost my mind, or at least if I have, that's not a sign of it. In Wisconsin, different groups of litigants filed separate suits in state and federal court. On April 29, 2014, the federal court struck down the law, but earlier this month, the Wisconsin Supreme Court upheld it. The federal judge found that approximately 300,000 Wisconsin voters lacked a qualifying photo ID. That's about 9% of the electorate there. He also found that virtually no voter impersonation fraud occurs in Wisconsin, and it is exceedingly unlikely that voter impersonation will become a problem in Wisconsin in the foreseeable future. So of those two things, we can show that there's no impersonation fraud problem in Kansas, and it's unlikely to become a problem. What we don't have that kind of evidence. A huge number, 9% of the electorate disenfranchised by the law. So the federal court in the Wisconsin case struck down the law on federal constitutional grounds. That case has been set for oral argument in the Seventh Circuit Court of Appeals in Chicago in September, which we're almost in. And even though the Wisconsin Supreme Court upheld the law under the federal order, the law is still on hold, so people won't have to show a photo ID when they go to the polls, and the law is still on hold. Pennsylvania, a state court struck down their photo ID law, and their governor, who's in a very tight race, decided not to appeal that. In May 2014, in Arkansas, a trial court judge struck down the law there, but he stayed his order pending appeal to the Arkansas Supreme Court, where it still is pending. Apparently the law is still in place, but it may be struck down. On August 8, after this month, after a week-long hearing, a North Carolina federal judge refused the ACLU's and other groups' request to put their photo ID law on hold. So the litigation results in photo ID cases around the country are decidedly mixed. In addition, the laws in these states were actually much more restrictive than the law in Kansas, at least for photo ID. And so far, we have not been able to discover the evidence of widespread disenfranchisement that we really need to challenge these. With regard to proof of citizenship, we filed a suit in November challenging this in Shawnee County District Court. We filed a motion and essentially in that case, we're challenging the very small group of voters who have used the federal form to register but haven't provided documentary proof of citizenship, and Secretary Kobach only wants to allow to vote in federal elections. So that bifurcated election system, we tried to challenge it in that case. The judge heard us in July and denied our motion, finding basically that striking down the law, putting it on hold for such a small group of voters would really create more problems than it would solve. So we were unhappy, but those are the stakes in litigation, and we move on. The biggest problem in Kansas is that the citizenship requirement has put 20,000 people on the suspense list where they're in legal limbo and unable to vote. We have tried to figure out a way to challenge that law, but so far we've come up short. Remember, the Kansas Constitution specifically empowers the legislature to adopt laws requiring proper proofs of the right of suffrage, which includes, and has always included, the requirement that voters be citizens. That means that this is a tough nut to crack through litigation. It also means this is really a political problem. The varied results in all of these voting rights cases shows that people of goodwill cannot count on civil rights organizations and courts to ride in and save the day. Constitutional law does not provide a shield against every bad decision that our legislators make. These are public policy choices, and legislatures have wide discretion to enact laws that, in their estimation, will advance the interests of the people. The state and federal constitutions establish a very large field of play for legislators. And it is only when legislatures clearly trench upon fundamental constitutional rights that courts will intervene. When the Kansas legislature passed the SAFE Act by an overwhelming bipartisan majority, without any evidence of any record of significant voter fraud in Kansas, we were disappointed. And we heard through the grapevine that some legislators voted for that law on the mistaken belief that organizations like the ACLU would ride in and file suit, and that the all-powerful courts would strike down the law on some mysterious constitutional grounds. That, my friends, is a foolish way to do the public's business. Legislation requires well thought out and well considered public policy decisions. The answer to these questions lies with the people and their elected representatives. Courts are only going to save the people from their poor choices in extreme circumstances. Thus, and no matter what you think, the circumstances are not extreme enough in Kansas. So do not rely on the courts. Thus, if you don't like the decisions that your elected representatives make, tell them so. If they don't listen to you, engage in the political process to elect different representatives who will listen to you. And who will make sound legislative decisions based on facts and legitimate public policy problems, not based on imaginary threats. Rather than passing voting laws that unnecessarily restrict the franchise, the Kansas legislature should return to the long arc of Kansas history, which bends toward expanding the franchise. Your legislators could do that in several ways. I'll give you a couple of examples. Colorado and Louisiana have allowed 16 and 17-year-olds to vote. I mean, not to vote, but to register to vote as they're approaching the age of 18, and when they apply for their driver's license for the first time. Right now in Kansas, you have to turn 18 before the next election in which you want to vote, before you can register. So that can be a very short window. My birthday was a couple of days ago, and you know that I'm just 18, so I was just able to register to vote in November. All right, another thing that the legislature could do would be to allow same-day registration for advanced voting. Kansas would add its name to Maryland, which just did that. In addition, Kansas could consider expanding the time for advanced voting. And of course, the legislature could repeal the SAFE Act. But those are political solutions and depend on responsible legislators to make sound legislative decisions based on real facts. So consider this. Changing the voting system in Kansas depends on you and the number of registered voters you encourage to remember in November. Thank you.